ये ना बेड पे अच्छा नहीं लग रहा मुझे। एक वो ला दो, स्टूल ला दो और मूड़ा ला दो तो बेटर रहेगा, वहां बैठ जाऊं। ये यहाँ बैठ जाऊं। ये बैकग्राउंड ना अच्छा सा नहीं लग रहा, कभी तुम आ जाओ लेटी हुई। मैं लाता हूँ, स्टूल भी लाना पड़ेगा। सामने वाली लाइट। मैं बंद कर रहा हूँ, कोई कोई गुस्सा चला है। ये गंदा है। Manan sir, can you hear me? Manan sir, can you hear me? Manan sir, can you hear me? Nitesh Mehra this side. Manan sir, can you hear me? Manan sir, I cannot hear you.
सर का माइक ऑफ है.
Okay. Okay.
Hello.
Good evening, sir.
Now you can hear me. Good evening.
Yes, sir. I can hear you. I can hear you, sir.
Thank you.
Sir, let us start, sir, by 5:50, sir. I think by that time you can have your this video
How
on
much
and the
time I
mic
have to
is.
speak it for 1 hour?
Yes, we have kept it for 1 hour. It will be started at 6 sharp.
Okay.
Okay, sir. Okay, sir. It was just a technical check with you. I think
Good evening.
everything
Good
is,
evening. Press shifts. You're unmuted for by host.
yeah, sir. Only you will be unmuted. Rest all will be muted, sir, during
Okay.
the session.
Okay.
And you are, sir, live on YouTube also right now.
Okay.
Live streaming is on.
Okay. Okay. Yeah. पढ़ लूंगा ऐसे ही. टाइम देखो क्या है. Okay.
Request all the audience and viewers remain on mute while we start the session with KK Manan sir. So we'll be starting it in a while. In the meantime, other viewers are also joining. So again, all of you to put your mic on mute when we start with the session. We'll be starting sharp. We'll be starting at sharp 5:55 or around 6 p.m. when all our participants will join. Since we have given the time to them of 6 p.m. Sir, we are so thankful to you that you are here in advance. And all the viewers can see you that sir is already there with us.
Thank you.
So we want another 5 minutes patience to be there till the time all the participants join the meeting, sir.
Okay.
Thank you so much, sir.
Good evening, sir.
Good evening. Good evening.
Good evening.
Good evening.
Good evening, sir.
Good evening.
Good evening, sir.
Good evening. Good evening.
Good evening, sir. Hello.
तो 5 मिनट पड़े हैं.
साक्षी किसका स्क्रीनशॉट लेना, यहाँ से जाके दिखेगा नहीं कुछ. Oh, shit.
बस. बस. डार्क करने में हल्का जा डार्क.
Oscar Pali. Oscar Pali. Good evening, sir.
नमस्कार जी. नमस्कार.
थिंक वो कंट्रोल कर रहे हैं।
हाँ वो कंट्रोल कर रहे होंगे।
नहीं, सब किसी ने करा था कि हम
ये कहाँ चला
ये
गया?
कैसे हो गया? दीप्ति देखना जरा, उसको करना। बस बस छोड़ दो।
You are
या ये
unmuted.
वाला
Right.
दबा, ये दबा दो।
दबा दूं?
Okay.
पार्टिसिपेंट में जाके देखो आप हो कि नहीं। प्रवीण कौन क्लोज ये
टाइम तो हो गया।
Hi everyone.
Has muted all participants.
Manoj sir, can you hear me?
Yeah, I can hear you little bit. Speak louder.
Yeah, can you hear me now, sir?
Yeah, I can hear you now. Can you hear me properly?
Can you hear me now, sir?
Yes, I can hear you.
So, yes. Your voice is very clear. So, we are starting with today's session. So,
should I start?
So, let me introduce. Sir.
Okay.
So, I, Nitesh Mehra, advocate on behalf of lecture series on law, would pleased and like to welcome Shri K. Manan, senior advocate, who is our keynote speaker for the today on the topic, the art of cross-examination. Let me introduce him. He is presently the member Bar Council of Delhi. Has been remained multiple times ex-chairman of Bar Council of Delhi. He has been ex-public prosecutor in Delhi High Court. He has remained an ex-senior central government counsel, and he has also remained an additional advocate general for state of Haryana in Supreme Court. And he has also been appointed as a special public prosecutor for ex-Prime Minister Shri S.D. Devegowda in a defamation case. So, sir, from here onwards, we are like to welcome you on behalf of the entire administrative team of lecture series on law. And, sir, from here onwards, it is over to you, sir.
Thank you. Good evening to my friends, dear sister and brothers. Let me thanks first of all to the organizers, led by Mr. Aman Sareen, who is a son of my dear friend. He is no more, late Shri K.K. Sarinji, and nickname Bobby, his wife Anu Mehta ji, and Nitesh Mehra ji, Priyanka Midha ji, and Sumit Chandra ji. They have provided me an opportunity to share my little bit experience which I have for the last about 40 years at the bar. I started my practice in the trial court in Patiala House Courts with a very great lawyer, late Shri Baldev Sai Mehta ji, and Shri J.R. Priyani, who is active in practice even now. And I learned a lot. not only from my seniors, but a lot of other seniors in the bar. Whenever I had an opportunity, I usually go to the courtroom to hear the cross-examination of good lawyers of Patiala House. Sometime I had gone to even Tisajari to hear the cross-examination of Shri Baba Gurcharan Singh, late Shri P.P. Groverji, R.K. Naseem Saab. Especially I had gone to hear the cross-examination of Shri P.L. Kalraj. Thereafter, I also had an opportunity to hear the cross-examination of big lawyers like
अरे क्या है कौन सी बात आ गई यही चाहिए
even senior of Shri Dinesh Mathur.
हद बजा रखी है
So I have whatever learned at the bar, today I will share with you. Cross-examination is a very difficult task, and it is important in advocacy. So far as cross-examination is concerned, it is a two-edged weapon. Main object of the cross-examination to find out the truth and the detection of falsehood in human testimony. And your object is to make the witness unworthy of credence or belief, or that he is not a reliable witness. For that purpose, you have to find out whether he is a previous convict. That can be done only through your client, stock witness, or interested witness, or has any enmity in the case with the accused. There are two types of cases. One is eyewitnesses case, the other is circumstantial evidence case. In circumstantial evidence case, you have to break the chain. You see, whenever you will be able to break the chain in the circumstantial evidence, you will be a successful lawyer. Otherwise, your client will be, that landed in the jail. For that purpose, you have to work hard. You should know the knowledge of your case thoroughly, the latest law point applicable in your case. Another point is, for the purpose of cross-examination, I said that knowledge and hard work. Hard work can't be replaced with anything. At the time of cross-examination, what I found, usually I was very rash lawyer. I had also adopted so many tactics. Even the judges usually tell the witness that don't see towards Mr. Manan, because I used to terrorize the witness, or I put my eyes in his eyes, sometime the witness, just to confuse him. It is my way of cross-examination, which is God-gifted. I say a number of times that cross-examination is also a God-gifted thing, which is not with everybody. But today's, whatever I'm sharing my experience, it is for the youngster, because so many good lawyers are there, better than me in the bar, who can cross-examine the witnesses better than me. But so far as youngsters are concerned, definitely I will share my views with them, share my knowledge with them, because I will advise them, whenever a good lawyer, you should keep a watch on the cases, whether it is in Tisajari, Patiala House. Now the new court has also come up in CBI's court, and Rohini, Kadkaduma, wherever it is, where the good lawyer come to cross-examine a witness, please go and see how he cross-examine the witness. It is very good thing and very good habit for a youngster, a young lawyer who enters in the bar. Don't shy. Don't think that you know and your senior will teach you each and everything. But my experience is that no senior can teach you what you will learn yourself, what you will learn from the experience. Automatically, whenever you will become a senior or having good experience, when you will destroy two, 3 cases, 5 cases, you will learn it where you have committed a mistake. Until you will commit a mistake, you will not learn. But it depends upon you whether you learn from your mistakes or you will continue committing mistakes. I think to become a good lawyer, don't repeat the same mistake. And for cross-examination, I'll give you few tips today. For that purpose, first of all, whenever in criminal case, first FIR comes in your hands, go through thoroughly. Don't read only once. Read at least 5-10 times. You will find the next time when you will read the FIR, the new thing in the FIR. You will find the lacunas in the FIR, whether the name of your client is mentioned in the FIR, what type of rule is prescribed in the FIR. Thereafter, when your client's remand will be sought by the investigating agency, don't unfold your defense at the time of police remand. Though I have every respect, recently we have seen in one of the very famous case of an ex-minister, number of mistakes have been done in that case because everything was unfolded at the time of remand. When you will reveal your defense at the outset, it will be fulfilled. That lacuna, whatever will be there in the end, will be fulfilled at the initial stage by the investigating agency. But you have to be very cautious about that. And for that stage, at the time of cross-examination, don't be impatient. Don't be so harsh. Be gentle. Be very calm. Show to the witness that nobody knows better than you anything. And you have to show to the witness that you have come here to speak lie, and I will take that lie from your mouth and will be placed on the table of the judge. For that purpose, if you will be successful, at the initial stage, the witness will tremble, will under pressure. But number of times witnesses have come in the court. Lady witness, you have to deal differently, very gently, very respectfully. And with the child, I will share my experience with the child witness. Very famous case, I have done it. I think the only case in the history in Delhi. That was a case of kidnapping in golf link. A child was kidnapped from the outside of the house who was ready to go to Bal Bharti Air Force School. You know, that child came to know after kidnapping within few minutes that child was kidnapped by kidnappers. The child was so intelligent. When the child came in the witness box, he was so intelligent. I know that how I cross-examined that child. Only one question saved all the kidnappers in that case, because I was also playing with the child in my own way. I make him understand that I'm your friend. Somehow, he has given the clue somewhere on identification. Merely on identification, those clients were acquitted. Though it was a case, true case, not a false case, but somehow we are performing our duty. So I'm coming straightway on the point, on the topic, that after reading the FIR thoroughly, wait for the challan. Don't rush to the bail. I know that in these days, client comes and insists the lawyers, whether it is a murder case, a Ducati case, any case, cheating case, get us the bail, get us the bail. But try to make them understand. Don't ruin your case, especially the murder case, Ducati cases, heinous crimes, especially session trial cases. Now, after filing the charge sheet, go through the charge sheet thoroughly and report under section 173. Go through at least 10 times. Thereafter, each and every recovery memo, memos, MLC, post-mortem report, and number of other memos are there. Please go through minutely. Thereafter, the statements of the witnesses under section 161 CRPC. Go through every witness statement under section 161 CRPC at least 10 times. You will get, whenever read the next time, new point. Now you see that I have a lot of juniors. Whenever a big case, for example, murder case comes, I call all of them and give file one by one, go through it. So I know anybody can give me a new point, and I don't consider them they are my juniors. I consider them my colleagues. So thereafter, before going to the cross-examine the witness, and one thing more, usually until you are sure that it is a case of discharge, don't argue on the point of charge. For discharge before the court, concede the charge immediately, ask the judge frame the charge. Sometime at the time of arguments on charge, you unfold a number of things, and judge also note down. Brilliant judges, and sometimes the judges, I do not name them, call them by name, they keep the things in mind where they can hook a person, hook a particular lawyer's client. For that purpose, please avoid arguments on charge and let the charge be framed. Thereafter, whenever the turn comes for cross-examination, there are two types of cases, as I told you earlier. One is circumstantial evidence case. Second is straightway case of eyewitnesses. Sometimes number of eyewitnesses are there. Sometimes sole eyewitness is there. Sole eyewitness you have to cross-examine very cautiously. You cannot take a chance of that witness anywhere, because you will not get the time again to cross-examine the witness until there is vital question left by you. Only you can summon that witness if there will be need necessary, and court finds necessary under section 311 CRPC. Court may summon him, court recall him, may recall not recall him, or you may have to approach the Honorable High Court or the Higher Court to resummon that or recall that witness. So single or sole witness, because today's era is the conviction can be held, man can be convicted even on a sole evidence. There are judgments are now. So my request before the young lawyers are, rather I will say that be thorough, be cautious before going to cross-examine the witness, and be sure, be very bold, very, you can say, confident that you know each and every thing of the case, nobody can shake your confidence at all. And you have to give the confidence. You have to show the confidence not only to the witness, but to the judge as well. You have to be very humble with the court. Though it was my mistake, I can concede it. I considered it at a number of platforms in my young age. I was very hot-headed lawyer. That was not good for me. Though I got so many relief in that situation also, but it was not good. I can concede that. My experience is I learned a very good thing from two lawyers. One from now the sitting judge, Honorable Supreme Court Judge Uday Lalitji. Whenever he enters in the court, he bow down his head. Whenever he leave the dais, he bow down his head before the court. Another thing, the same thing I learned from Shri Ayub Khan Sahab. Whenever he enters in the courtroom, he bow his head like anything. One should be very humble before the court. You see, in the criminal court, you must remember, a lot of discretionary powers are with the criminal court. Always with the court, if you are humble, your attitude with the court is very good, and you give an impression that you have high regard for the court, you have every respect for the court. Court also want that maximum relief can provide you by the court. So remember this thing, that before entering into cross-examination, now I will tell you a few things that which I have noted down from my experience, that sometime hostile witness. Now you have to see whether you have to cross-examine the hostile witness or not. Mostly, don't cross-examine the hostile witness. I saw a lot of people, lot of lawyers cross-examining the hostile witness. And sometime prosecution also tender the witness for cross-examination. Now, whether we should cross-examine that witness for cross-examination, I say no. When he doesn't say anything against you in the examination in chief, why you should cross-examine that witness? But I found so many lawyers have started cross-examining and damage their case. So my request would be, learn this lesson on two things. The witness who was tendered for cross-examination by the prosecutor, don't cross-examine ever. Two, hostile witness. You can cross-examine the hostile witness. Mostly, hostile witness, I don't shy. I can concede to this extent. Hostile witness are usually, before going to the court, meet the defense counsel, because he usually win over by the client, used to bring that witness to the lawyer. Lawyer used to teach him each and everything. Even sometime lawyer also teach him that he can ask you such and such leading question, you say yes and yes, no or no. Whatever suits to that defense theory, he can be tutored by the defense counsel, but not in everything. Sometimes natural, where the prosecution, the investigating agency has planted a witness without his knowledge and brought in the court, and he became hostile because he doesn't know anything about the case. And sometimes you find, usually it is the duty of the investigating officer to be there on each and every date, especially on the crucial evidence of material witnesses in murder case, dacoity cases, session trial cases, but usually they don't come. If they come, they also prepare the witnesses and tutor the witness. For that purpose, you will be very cautious even after tutoring you if the witness comes in the hands of the prosecutor or the IO. Now, then you have to see in the witness box whether the witness become hostile or not. And if he does not become hostile, then you have to, when your turn comes to the cross-examination, put initially 2-3 questions which are irrelevant, just gauge him whether he can toe your line or not. If he toe your line, then cross-examine on your own line, otherwise cross-examine him on merits. Because he doesn't give you any room, he was tutored by the investigating officer and he was under fear of the investigating officer, so he gives the evidence in the examination sheet whatever the investigating officer tutored him. Tutor witness always does not stand much on his legs. So it is up to you to what extent you can shake his confidence. For that purpose, it is your caliber when you cross-examine the witness. So I will give you few more tips subsequently. First of all, I would like to tell you how many types of witnesses: eyewitness, expert witnesses, and writing expert, medical doctor witness comes in the witness box. For the expert witness and for the doctor, you have to consult another doctor that this is the MLC or this is the post-mortem report of the doctor and this is the opinion of the doctor. What type of questions I should ask from the witness? If you have some doctor, good doctor in your contact, please consult him. Even sometime the witnesses come from the CFSL, FSL. Those witnesses also, you have to put questions very cautiously because they are very expert witnesses. They are the witnesses who are not the false witnesses or who are not the witnesses who are planted witnesses. They are natural witnesses. They have examined the material, whatever sent by the investigating agency to the FSL. The doctor, whatever the post-mortem they have done it, whatever the cause of death they have given it, they will stand by that. For that purpose, you have few questions to put before them, and those questions are very relevant questions, should be not just in the air. Please be careful while cross-examine the doctor, the scientific, the persons who comes from the CFSL, and thereafter the investigating officers comes. And in criminal cases, the dangerous witnesses are, so far as police is concerned, police constable is a very dangerous witness. Very easy witness is IPS officer. Higher officials are very easy witnesses. But constable, head constable, sub-inspectors, and simultaneously the villager. Whenever any villager come in the witness box, it is not easy to break that witness. For that purpose, you have to gauge the depth of that witness by putting here and there few questions at the initial stage to gauge his mind. Be careful, be friend with him, make him sure that you are his friend. Sometimes it is your caliber, how you mixed up with the witness. So you mixed with the witness to the extent that witness has come for a purpose to depose against you, or I mean your client, so he should forget that for what purpose he has come. So you have to cross-examine him. Another witness comes, very important witnesses of test identification rate, which is very, very important point in criminal cases. Lot of lawyers do not consider a TIP. So witness is a worthy of credence. We have to cross-examine those witnesses who are of TIP. TIP's witnesses are to be either the magistrate or the persons who have identified before the magistrate. Out of 10 people, the only accused who have been seen by them. And while you will cross-examine the person, recently I was cross-examining one lady. He has that's my perception, and I hope that I will be successful in that case. She has instituted a case against her husband. There was a dispute between husband and wife for the custody of the children. When the wife doesn't have any alternative, because the children were having all love and affection for the father, she instituted a case of molestation through her daughter. I will not elaborate much still because the case is pending trial, but sometimes documentary evidence is there. A man can tell lie, but the documents will not. It is the phrase in our legal profession. Man can tell lie, but the documents or the circumstances will not. So sometimes documentary evidence is also there. We had to go through the documentary evidence, which is also very dangerous. You have to rebut documentary evidence very diligently. You have to take the assistance of your client for that purpose. You cannot alone rebut the contentions of the complainant or that witness. You have to take the help of the books, latest law of the land, that is especially of the Honorable Supreme Court or various Honorable High Court latest judgments. And cross-examination is always on the latest point, latest judgments of the Honorable High Courts and the Supreme Court, what type of law is being delivered latest. On that point, you have to bring the witness in the cross-examination to the point that here is a case which falls in that category. If you will be able to bring the witness in that category, and you will be able to cross-examine the witness and bring out the truth from his mouth and place it on the desk of the judge, bring it on the record, case file, then you will be a successful lawyer so far as cross-examination is concerned. And few more things I have written for you for cross-examination, that as I said, you see that in CFSL, case property which is sealed by the investigating agency, usually they don't seal at the spot. It is our vast knowledge. They seal at the police station, but show that they have sealed it at the spot. But sealed case property used to be deposited by one constable taken from the Malkhana order and deposited with the FSL office. Also, there are judgment of our own High Court and the other various High Courts and the Honorable Supreme Court. Seal is also important factor of the case property, for which every lawyer will never overlook that angle of seal. you have to cross-examine the witness on a seal also. A very few lawyers are there who are master of cross-examination on the point of seal. You see, there should be a link, complete chain from depositing the case property in the Malkhana till it reaches the FSL office. To that, this case property has changed number of hands. Now it is up to the lawyer who is cross-examining the witness. Sometimes few lawyers think that they are a very not important witness, or a witness can't be cross-examined on this witness. But my perception is this witness is a very important witness. It is not a formal witness. And I got acquittal in a number of NDPS cases. Earlier, when NDPS cases was not there, technical points in NDPS, in recovery of chars, opium, earlier when NDPS was not there, in Excise Act, seal was also playing a very vital role while you cross-examine the witness. So my request would be, don't think that the persons of seal who took the seal or deposit the seal or deposit the case property with the FSL are formal witnesses. Please cross-examine. Before cross-examining, please go through properly the recovery memo, their statement under section 161 CRPC. Usually the statement under section 161 CRPC is not there of FSL officials, but you can cross-examine them. You see, they will leave lot of points, lot of lacunas. And lacuna word in criminal prosecution is very vital and is a very important point. Wherever the lacuna left by the prosecution, and you will not allow the prosecution to fill up the lacuna in the prosecution story, then you will be a successful lawyer. Sometime you put a question, judge says, irrelevant, disallowed, I will not allow you to put this question. But you can request the court with respect, with gentle manner. Please, sir, write down my question and disallow it. So you can challenge that order before the higher court. If that question is relevant, then higher court can allow you to cross-examine or to put that question to the witness. Sometime you leave few questions and you realize subsequently after examining the witness. You move an application under section 311 CRPC. Court doesn't allow. Again, you have to go to the higher courts, but you have to convince the court that inadvertently, or you were not known few facts of the case come to know subsequently. So in the interest of justice, that witness can be re-examined with the cost usually the Honorable High Court allow you. One opportunity used to be given. So don't leave any chance while cross-examine the witness. And I'm giving you today, I have written down whatever my experience is today, one by one. Be brief as you can be in cross-examination. Don't be lengthy or do any lengthy cross-examination, because whenever you earn points, you are bound to lose subsequently whenever the witness realizes and he can fill up that. So be brief. Another point is your question should be very simple. State, understandable by the witness. It should not be confusion. There should not be any confusion. And a stop when you got whatever you want from the witness, immediately stop your cross-examination. You found the question's answer in your favor. Then at least if you don't want to stop your cross-examination, at least you shift your line of cross-examination, ask the steno, naya para, change the paragraph. So after gaining that point, remember that you will not again come on the line which you have already gained. You don't give an opportunity to the witness to again answer and destroy your point which you have already gained. Then pin down the witness when he has given a favorable answer of your questions. Remember that always. Few points which I learned from my cross-examinations. Do not cross the witness unless you have to, because sometimes there is no need to cross-examine the witness. Nil opportunity. Unnecessarily don't cross-examine the witness if he doesn't say anything against you in the examination in chief. So unnecessarily don't cross-examine the witness just to satisfy your client or satisfy your ego or satisfy yourself. No. It is the client in whose interest you have to cross-examine the witness. If there is no necessity to cross-examine the witness, please don't cross-examine the witness. Do not go fishing or answers unnecessarily. Sometime I found many lawyers started fishing. Don't do this with the witness, at least because he is also respectable. He has come to attend the court to give the evidence, whatever he knows. If he is a false witness, naturally you will rebut his whatever he has stated in examination in chief, whatever he has said. That is why you are cross-examining him. Do not ask the questions, the answer to which you yourself do not know. Sometimes you yourself do not know the answer and still you are putting the question. I have seen few lawyers. Sometimes we 4 lawyers for 4 accused. I found few lawyers, but I tried to stop them. They also gratefully, I am grateful to them, stopped. When I made them understand, no, don't cross-examine. So my other colleagues who are well learned, better than me also, they also do and adopt the method whenever more than 1 lawyers in one case. Don't allow the witness repeat the evidence given in chief. This is very important. Sometimes you will find you put a question, he doesn't give the answer of your question, but he tries to give the answer whatever he has already stated in examination chief. Try, tell the judge and make him understand that what type of questions you have put him. Ask him to give the answer first of your question, then whatever he wants to say, let him say, but first let him give the answer of your question. Don't allow him to repeat the examination in chief. Another point is that don't enter into arguments with the witness at all, because you don't know. वो कहते हैं ना अपनी इज्जत अपने हाथ. Sometime बदतमीज and witnesses thinks that they are more intelligent, capable. They don't respect the lawyer. For that purpose, try to overlook their whatever they say and concentrate towards your aim that you have come to cross-examine him. Rather, you please make him understand politely. Gentlemen, you have come to depose. If you don't understand my question, please repeat it. I can repeat it. You can ask number of times the question. I can repeat it. But you don't go here and there. Please answer my question first. Thereafter, if you want to say voluntarily, you say whatever you want. Please compel him to answer your question first. Thereafter, whatever he wants to say, let him say. That will sometime the judge dictate that his answer. Sometime even the judge says it is not relevant. No, he is not going to dictate whatever he wants to say again. Another point is, don't put question which is fatal to your case. That is why I said at the outset, you should thoroughly go through your case. You should know what type of questions you have to put to your witness. Sometimes a question is being put by a lawyer which is fatal to your own case. Remember, mostly the investigating officers tutor their witnesses, and in these days, in most of the cases, in trial cases especially, complainants' counsels are there. They also tutor the witnesses. So be very polite and don't put any fatal question which become headache for you even tomorrow at the time of final arguments, and you may not be able to come out from that answer in your final arguments. Maybe there will be a latest judgment. It depends upon your luck or luck of your client. But request would be, don't put a fatal question which will be a fatal for your own case. Another point, a very important point, change your mode of cross-examination. During cross-examination, you have to change mode of cross-examination. You have to read the psyche, the body language, the impression, the mind of the witness, whether the witness is illiterate, aggressive, very talkative, or foolish, or very intelligent. It depends on you. How you tackle that client, the witness. It is up to purely on you to tackle the witness. Witnesses are not aliens. They are like us. I became witness only once in my life. To become a witness is also very horrible, and it is not so easy. I became a witness in Deve Gowda's case when I filed that case as a prosecutor and being cross-examined by Shri Ram Jethmalani, legal luminary of the country, and my great I can say lawyer Shri P and Lekhi ji. Both were cross-examining me. So I knew how I came out from their clutches because I knew my facts. I sat with Devegowda at least 3 hours daily. I knew his whole history now, since his childhood. And it is with me only. Last person to tell anybody. It is in between him and me. Ultimately, that case was also resulted into a compromise. It was against a member parliament. One BJP sitting member parliament was there from Karnataka. When he found they were unable to get anything from me, because I was the sole witness in that, being in defamation case on behalf of Devegowda. They also wanted to cross-examine Devegowda, for which he was also escaping. So, in defamation cases also, I've forgotten about defamation cases to tell you, very dangerous. It is very easy to file the defamation case, but it is very difficult to come out, because in defamation cases, anybody, the defense counsel can ask you at least for the last 3 generations, what were you? What was your background? Character assassination can be done in that case. Any question can be put, but with limitations. Anyway, again, I'm coming on the point, whatever my experience is. Don't cross-examine the witness so as to give reasons to the prosecutor to re-examine the witness. Sometimes we cross-examine the witness, we bring the points which the prosecutor could not bring it in the examination in chief. So we used to bring it in the cross-examination. Immediately, the prosecutor will move an application under section 311 CRPC before the learned magistrate or additional session judge. And usually, the judge will allow that application. Again, the witness will be re-examined. Though you have the opportunity to cross-examine the witness, but my request would be why we should give an opportunity to the prosecutor to re-examine the witness. Because don't touch the witness to that point which the witness has never deposed against you in the examination in chief. Sometime you put a question in the cross-examination because you have gone through the statement under section 161 CRPC, and you inadvertently or advertently or ignore, I will not use that word. I will say whatever, I mean, your wisdom says, one's wisdom says, you put a question. So the witness explain or unable to explain. So you will give the chance to the prosecutor to get re-examine the witness, and whatever the lacunas in the prosecution story left by the prosecutor or by the prosecution, again chance to fill up those lacunas in the re-examination. It is very important to see. Good lawyers never do this. I have seen many good lawyers. Even today, whenever I found one day, I was sitting in a Saket court, one of a young lawyer was cross-examining the witness very intelligently. I was very happy. He was thorough of his case. But at the same time, I found, I will not name them, at least I will name the judge. Shri Prem Kumarji was the additional session judge in Patiala House. We 4 lawyers were there. I cross-examined first, thereafter 2 others. When 4th lawyer came, I told in his ear, I whispered, okay, sir, 1 question is left, you are not asking that. Again, the judge asked him, okay, Mr. Counsel, 1 question is left, you please ask that question and sum up your... He put 20 questions, but he could not then put that question. Ultimately, in the interest of justice, Prem Kumarji put that question. That question was of a TIP. So, young lawyers, I find, brilliantly doing their work in trial courts today. A lot of appeals I am doing. I am reading their cross-examination. Brilliantly, they do cross-examination. Be proud of them. I told them, work hard. You will be one day Baba Gurcharan Singh, P.P. Grover Sahab, B.L. Kalra Sahab. And though criminal lawyers, day by day, death is there. I don't hesitate to say. They are not filling the gaps. We have shifted to the, I don't say I'm a very good lawyer, but I say, Kaam chalao the. One another, my fellow, is also shifted to the High Court. So, even in Tisajari also, one lawyer is doing Tisajari and Roni also, doing very good, coming up very well. So, my request before you people, go sit in courts, see how other lawyers cross-examine the witnesses. Don't entirely depend upon your senior. Every youngster cannot get good seniors also. Every senior is a senior. We say every lawyer a learned colleague, but I don't hesitate to say 5, 6 lawyers I found sometime very awkward. 6 lawyers going behind them. Wanted to ask them, can you tell me how many sections in the CRPC or the IPC? But what you can do, system is changing. Things are changing, but it may be contemptuous. Many lawyers may be feeling that what I'm saying, it may be pinching to them, but it is hard reality. Please keep the junior only then when you are at least little bit master of your own field. Don't keep them. Don't ruin their career. And they should also know with whom they have to go. And every newcomer, I advise you people, start from the trial court. Jethmalani ji started from trial court. A very great lawyer was Rajinder Singh ji from Jabalpur. He did cases of Indira Gandhi ji. Indira Gandhi ji has given him Rajya Sabha membership. He refused and handed over the Rajya Sabha within 6 months to Indira Gandhi ji back. He said, I'm misfit. He told this thing to me. I'm fortunately, I did Chandra Swami's matter with him. I did few more cases with him. And I learned a lot from him. I learned a lot, though I did only one case with Shri Juju Lalit ji, Uday Lalit ji. Now he is the Honorable Supreme Court Judge. I learned a lot from him. The way he argued in the court, the way his body language was. So be humble in the court and respectful to the court. Cross-examination is comes at the very later stage. Another the last point which I wanted to show, and wanted to tell you people that so far as cross-examination is concerned, that you should not give an opportunity to the witness that he should rebut his mistake he has already committed. Try that repetition of your question should not be there, and try to cross-examine the two eyewitnesses simultaneously on the same day. Insist upon the court that if there are two eyewitnesses, please, sir, record their examination chief first, both of them, and I will cross-examine both of them together. Don't give an opportunity if you will cross-examine the witness one day, one witness, when you will cross-examine the the other witness on the other day, he will unfold your total cross-examination to the earlier witness. And in the cross-examination, a big question always before you, that whether you will be able to cross-examine this witness. Don't afraid. But you think that witness is nothing, you know your case, you have the mastery of your case, without any fear, put the question, give an impression to the witness that I'm your master. Put your eyes in the eyes of the witness. Make him understand that you have come here to depose. If a witness is planted, he will not stand before your cross-examination if you have gone through your facts of the case properly, if you know the latest law of the land, especially the Supreme Court or various Honorable High Court, which totally applicable on your facts of the case. Bring the witness, put the question to the witness on those lines, which is the latest law of the land, which is the latest law applicable in your case, fit in your case. Sometime you will find a stock witness is there. It is very difficult to break the stock witness. But you have to put the question, in how many cases earlier you have to appear as a witness. Give the detail of all the cases. Sometime he will withheld the information from you. He will say, no, I will never appear in any of the case, because he must have been tutored by the investigating officer on that line. For that purpose, you have to give the duty of your client to take out. And in these days, Google is there, lot of technology is there. If you put the name, father's name and address, sometime you will find it. In CBI cases mostly, name and father's name is the correct, but the address of the witness is incorrect. They don't give the correct address of the witness. And you will find it in the CBI cases. The mode of CBI cases is totally different than the state police. Delhi police, the investigation is totally different than other states. And you will find the investigation. You will have to take out whatever the weaknesses of the prosecution. You have to bring out the weakness of the prosecution, and you have to put your defense. One more thing, which I inadvertently forgot to tell you, that you have to put the defense in the suggestions, your total case. What is your total case? You have to give these suggestions to the eyewitnesses and recovery witness and to the investigating officer. One case I'm doing it. My client never told me, never apprised me that he is mentally not sound. He is involved in a murder case. One day, I not named the judge. Judge told me, Mr. Manan, I think this man is not mentally sound. When I saw him, I was sitting in my courtroom. Then I called his parents. I found that the boy was insane. I could not take that defense from the very beginning. And his mother is insane. His sister is insane. He is insane. And he committed murder. After committing murder, he never ran away. And he bolted himself in the bathroom. Nobody can do. He will try to run away from the spot when he has an opportunity. By the time I prepared an application for his medical examination, that judge was transferred. Another judge came, but he put the query before me, Mr. Manan, after 3 years, you are coming with this application. I apprised him, but he did not agree with me and dismissed my application. Then I approached the Honorable High Court. Honorable High Court agreed with me, got his medical examination conducted. Ultimately found that he is not sane. He is a mental case. Reports have come, not for the last 1 year or 10 days, from the day one when he was lodged in the jail. Its reports are there. So, sometime we have to take out the facts, truth, and information from the clients also. It is like a kishti. एक चप्पू आपके हाथ में है, दूसरा चप्पू क्लाइंट के हाथ में है. So, if both will swim together, will take the kishti together, then boat together, then you will be able to cross the bridge. Otherwise not. You will cross the river, then otherwise not. So client is also equal weapon as you are. So don't forget to have the assistance from the client also. Ask each and everything from the clients, his parocars, especially the accused. Still, a latest case, I'm doing a murder case, very famous case. Lot of things I have taken it. He told me the truth, that he had an affair, but he has not murdered that lady. Lady was, though I will not disclose my defense today, lady was killed by her own. But still I say that I'm withholding my defense from the public because main witnesses have not come so far. Hence, my request to the young lawyers is that you people are the future of this country, future of this fraternity. Out of you, lot of people have to become the judges. Out of you have to become good lawyers. Out of you people have to become good government lawyers, attorney general, solicitor general, additional solicitor general, and good lawyers, I will say. When we will become old, we will say, yes, I have seen this lawyer when he was a young. We will say we are proud of you. I have more than 500 lawyers who have gone from my chambers. Few are judges even. Prosecutors are also there. And good, they are doing very good today. Proud of them. When I see them, sometimes few lawyers come against me who were my juniors. I feel very happy at that time that he was my junior. Today he is opposing me and opposing very diligently. If I lose a case from him, I don't feel. I feel happy that he is my disciple. Losing a case, winning a case, it is totally a different thing. Another thing which I have forgotten to tell you. Never think, never take to your heart that you lost the case. No. If you lose a case, you will learn something. But learn something. You must learn. Don't leave in between or don't desert. Feel that you have learned, you have lost the case, but you have won the heart of the judge, heart of the client. Lot of 1 or 2, maximum 10 cases out of I think 1,000 cases, more than 1 lakh maybe, for the last about 40 years. In September 19, I will complete 40 years at the bar. I can say I have completed more than 1 lakh cases. I'm sure. I know it. Earlier, when I was in Patiala House, mainly, now courts are bifurcated. Mainly, I shifted towards the Honorable High Court, though I do cases in the trial court. Patiala House is my Janam Bhumi. मैं गर्व से कहता हूं मैं पटियाला हाउस से हूं. जेठमलानी जी started from district court और राजेंद्र सिंह जी started from district courts. They both advised me, accept the case even before even anybody, whether 107, 151 CRPC. You are accepting the brief. It is not a question whether brief is small or big. You are performing your duty. I did one case against Jetmalani ji before in Chanakyapuri before the one ACP. He came there. When I told my senior, he said, I know. He doesn't shirk to appear before even ACP. I did cases against him also and with him also. I learned a lot from both of them. I did learn cross-examination, the art of cross-examination from Rajendra Singh ji, from Baba Gurcharan Singh ji, aggressiveness, style from Shri P.P. Grover ji. But I know of cross-examination, my style is of my own. Everybody knows it. My cross-examination art, I never say though I learned few things from my seniors. Grateful to my seniors Shri Baldev Sai Mehta ji and J.R. Priyani ji. Whatever I am today, I am because of you people. And simultaneously grateful to my juniors also. They assisted me always. Good juniors have come in my chamber, in my office, became judges, prosecutors also. It was their hard work. So I will request, not direct, to my juniors, junior lawyers, young lawyers. Be bold, be confident, be thorough of your case. Go through the facts of the case before going to the witness to cross-examine him. Think that you are the master of your case. Nobody cross-examine the witness better than you. You should be confident to that extent. Don't afraid. Sometime it is the tendency now I found. Judges are scolding. Earlier, judges were not scolding. Rather, I know I started my first cross-examination in the court of the then Metropolitan Magistrate Shri J.M. Malik ji. Now later on he became High Court judge also. Other magistrates were also there. Shri Prem Kumar ji. They used to tell my senior, please leave this case here, Mr. Mehta. Let Mr. Manan cross-examine this witness. Please go and read his statement first. So likewise, every senior also should encourage their junior. Give here at least small cases in which you can overlook one witness to cross-examine. Let them cross-examine that witness. You stand behind him, or rather I will say, leave him alone. Send him alone in the court to cross-examine that witness. If he wants any assistance from you, guidance from you, please guide him. Ask him to write down the questions. And don't write down the questions. Write down roughly. Don't write down all the questions. Otherwise, when you will be able to put or finish all the written questions, then you will not be able to cross-examine the witness further. So write down the main points of the
Hello.
सर का वॉइस चला गया.
I am on behalf of KK Manan sir. There is a technical issue, and we will work.
Okay.
We will come back within 5 to 10 minutes.
Okay, then we are holding. No problem.
Okay.
No issues. Thank you.
I request everyone to remain online. We will be coming back again in 5 minutes. There is some technical problem at the end of KK Manan sir.
Yeah, because he was about to conclude and suddenly this happened.
Yeah. So it's the technical problem at his end. So he's just taking care of it. So he'll be back in another 5 minutes. So I request you all to be remain online
No, no,
for
no,
concluding part of.
no, we are here only. We are not going anywhere. And I request you that in the further, like whenever you are going to do such session, please keep inform us.
We will definitely. You can leave your WhatsApp number if you feel like on the chat. We'll take it from there and we'll add you in
Okay,
the group
fine.
with
Yeah, sure.
your
We are
name on.
waiting. No issue.
Yeah.
We are waiting here. Thank you.
So yes, we have sir back. He'll going to start in another 1 minute. Is about to join. Can you hear us, sir?
No, we cannot. Hello?
Manan sir, can you hear us?
No.
1, 2, 3, KK Manan.
Yes. We all can hear you, sir.
We are
all can.
audible.
Okay. Just within 5 minutes, I will come up.
Sure, sir. Sure. Please.
You are audible, sir.
Okay. Should I start it?
Yes, sir. Yes, you are absolutely clear, loud enough, sir. We all can see you.
Okay. Sorry for interruption. Technical problem. I was not with you people. Only 2 points are left on for which I would like to tell you that I already told you about the case of eyewitnesses. Now the second case is of circumstantial evidence. In circumstantial evidence case, we have to break the chain. You see, wherever and whenever you have been able to break the chain in a circumstantial case, whoever the witness is being brought by the prosecution, then you will be successful and you will get the acquittal. If you will not be able to break the chain in circumstantial evidence, then there will be a problem. And earlier also, one thing which I inadvertently left, a very important thing in the cross-examination is, whenever you cross-examine a witness, first you go through the examination in chief and compare that examination in chief with the statement under section 161 CRPC. If there is an improvement by the witness in the testimony in the examination in chief, then you will have to confront of that improvement which was done by the witness in the examination in chief. Those portions you have to confront it in the cross-examination, and for that purpose you will have to put a particular question sometime in the question form or sometime in a routine. Sometime the complainant's counsel or sometime the court, and sometime the witness doesn't agree. Then you please request the court that you will put a question in a question form, let him answer. Then you can confront that witness with his earlier statement under section 145 of Indian Evidence Act. It is privileged with you, with the lawyer, that you can cross-examine the witness. While cross-examine the witness, you can confront that witness with his earlier statement, which is improved by him in the examination chief. So with these things, I will say thanks that I took a lot of time of you people, and hope that whatever I learned, I shared with you my experience. And again, I'm grateful to the team of Aman Sareen, Ravi and his team. And you see that it is their efforts, Anuji, Nitesh ji, Priyanka ji and Sumit ji, that I have shared my experience with my younger brothers, sisters, and with a lot of other colleagues. I'm also grateful of those people who were hearing me. You have spared valuable time for me. Thank you very much.
Thank you, sir.
Thank you.
Thank you, sir. Thank you, sir.
Thank you, sir.
The lecture series on.
Thank you, sir.
Thank you, sir.
Sir, it's a
Love you.
Thank you, sir.
huge
Thank you very
respect, sir.
much.
Thank you.
Thank you. Thank you, sir.
Lecture series on law is also thankful to you for the wonderful lecture on this art of cross
You have
examination.
taken a very good initiative, and in criminal law, lot of branches are there, and you can take a lot of other lawyers also on that in your.
Sir, next time 156.3 along with 173.8 and all. Can it be possible?
173. I will give you another topic, very good topic, which is not being taken usually by anybody. Let me think over it. I will give you a very good topic.
Sir, we are waiting for this. When you are coming
I'll
again
give you
live.
by tomorrow itself, no problem.
Okay, sir. Thank
sir,
you so
thank
very
you
much.
so much,
Sir, only one thing, I have received many of the questions from many listeners and viewers. If you can take up, sir, only one question.
Yeah, tell me.
Sir, this is with regard to the cross examination in a 307 case when the witness is himself the injured.
Yes.
And how to cross examine that in that case, sir? That's a common question which has been asked by most of the viewers, sir.
In such type of, in the 307, usually the one has, because he is the injured witness. We have to cross-examine that witness very cautiously. And so far as the defense is concerned, usually the people say, most of the lawyers give the suggestion that you have sustained injury by fall. If the injuries with sharp weapon, and weapon always used to be shown to the doctor, which is being recovered from the accused, whether that injury sustained and can be possible with that weapon of offense. For that purpose, the cross-examiner has to be very cautious to put a question, and he will have to see the weapon of offense not once, number of times, and have to see the medical jurisprudence, especially medical jurisprudence to the extent of injured.
Thank you so much, sir, for the answer on the same. I think with this, we are going to conclude the session. And I am also telling all the viewers and all the listeners that the entire session of KK Manan, sir, has been recorded by us, and we are very soon going to circulate the same to all of you. Thank you so much, sir, for the very wonderful lecture on the.
Thank you. You are doing wonderful job.
Thank you so much, sir, for your kind words. Thank you so much.
Thank you so much, King.
Thank you, sir.